Mary, do you have a name for this case?
Alex Baker and the petitioner, Ann Gorgolis. You don't need to talk. Ann Gorgolis.
Yes, and you're representing the respondent.
Yes, ma'am. So much fun. I haven't been in life court.
Oh, so you're
Well, but going in, I'm talking about going into the courtroom.
Right.
Instead of Zoom.
Right. Oh yeah, I prefer live for sure.
Yeah. I mean, this is like, I love the, all right. You know, I love the whole pomp and circumstance. And Zoom is like, okay, I'm calling the case. This is my favorite fact right now. ¿Entiende? ¿Habla español? Un poquito. Habla français. Vous parlez français?
We're going to calm the rank.
Un poquito.
I would say
Ah. Quand je suis ici, je parle français magnifique.
it's beautiful language. I studied it really only to read Montaigne.
Montaigne.
That's the only reason I did that.
So my friend,
And you know what's funny? Montaigne wrote his essays in Latin. So I'm going to learn Latin.
my friend gave me the Little Prince
Yeah.
to practice my French, and it's sitting on my shelf. I'm such a fired friend. Do you remember petitioners? Okay. No. Okay. See, this is where he's like super helpful. You have a stipulation.
Good now? Yeah.
Okay.
Okay,
Remain seated and come to order for the beginning session.
so, welcome back. You can just be seated.
Thank you.
All right, so in the, I'm not sure how you pronounce this, and I apologize. Georgilis matter. So, Ms. Georgilis and Mr. Baker, you are on mute. Are we on mute? Okay, so, Mr. Baker, you're there. No, you're on mute. Okay. Yes.
Yes.
Mr. Julis, are you there? You're on mute.
I'm texting her. I think she maybe just stepped away for a moment.
Okay, well, so let's do this while we're waiting. If you can get her back, that'd be great. If I can just have everyone state your appearance for the record, please.
Alana Chazen, counsel for petitioner, and Georgie Liss, who should be appearing via Court Connect.
Good morning, Your Honor. Tracy Henderson for respondent. Mr. Younger is present with me as well.
Got it. So, I apologize for all the sort of fits and starts this morning, but we'll actually get there. Mr. Baker is your paralegal, is that right?
Yes, Your Honor.
Good afternoon. This is Alex Baker, paralegal for attorney Tracy Henderson.
I can step out and try to call her. She's a doctor and had some stuff that she had to deal with at work this morning, but I know she's available. I think she just stepped away for a moment.
Okay, you can call her from here if you want. You can also not call her from here, whatever you want.
I texted her.
Maybe while you're doing all that, maybe we can get some preliminary stuff done so I get a sense of what we're doing and how long it's going to take and all that.
We're back.
Are you leaving?
Okay, yeah, just make sure to unmute yourself. Okay.
Oh, I like your stuff. I was so uncomfortable. I stayed in silence. Oh, so how did you go yesterday? Did you go to a meeting? Did you meet the bulletin? Okay. 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 Fun. When's your job interview? Okay.
Okay, so, I'm assuming,
She says she's on.
well, if she is, she's muted and her camera's not on. I don't know. Is she, can you tell?
Okay, can you hear me at least? Good. I'm in I have to do this by not Wi-Fi. I'm sorry. And so I think my signal's just weak.
That's okay. All right. So, all right. So, as I understand it, this RFO deals only with, so you two have 2 children, correct? Got it. And actually, sir, well, I'm not going to worry about this. There's 2 kids. And the RFO that we're dealing with only deals with James or Luna.
James.
Is that correct?
Sorry, under James or?
Luna, L-U-N-A. Is that correct?
James, yes.
I'm not going to go down that trail.
Could the petitioner mute?
So I'm not,
There we go.
Ms. Georgoulis, I'm not sure what you're doing, but it sounds like you're dragging paper across something. There we go. All right, so. Where does this child currently reside?
With petitioner.
In Texas?
No, here in Los Angeles County.
California. Okay. You live in Texas?
I live in California now.
Fair enough. So there's no issue about this court's jurisdiction?
No, Your Honor, we have a stipulated order transferring it. It's actually if you want to see it, page 150 of petitioner's declaration, PDF page, in support of her RFO.
There was a transfer order from the Texas court in November.
Got it. Okay, got it. So, were you 2 married?
The marriage was annulled and found void by the court in Texas.
Okay.
Yes, they were married.
I don't, these are just, I don't care. I'm just trying to get preliminary. So has there been a parentage?
No.
Judgment of parentage?
No. It's never been challenged that Ms. Georgoulis is the mother and Mr. Younger is father. That's never been challenged.
So will there be a stipulation of parentage?
There was a judgment entered as to parentage in the Texas matter, Your Honor.
Your Honor, that's actually a misrepresentation. The names of the things in Texas are different. Like conservatorship means something else in California. So that's just the title of the document. Parentage has never been challenged. That's not an issue here. What's at issue is a 12-year-old's medical.
No, okay,
Yeah.
but you're asking for, mom is asking for sole legal custody.
No. The main issue here is whether or not to put a 12-year-old through the dangerous gender-affirming care.
Okay, well, hold it.
They want to stop puberty.
Oh, whoa.
Yeah.
Stop. Okay, so at the end of the day, I'm not going to order medical care one way or the other. I'm going to designate a sole legal custodian or joint legal custodian. I am not going to manage this child's medical care. So we're all on the same page.
So she was given full, I apologize, I'm a civil attorney, so I'm not going to speak the right language.
Family law is an entirely different animal.
Exactly. So she was given the right to make all medical decisions with the very important exception of putting the child.
Oh, okay,
I'm
time out.
sorry.
You've got to slow way down too. Mercifully, we have a court reporter. When this case actually goes to a hearing, if you want a court reporter, you're going to have to provide one. But you have one, so slow down.
Okay, so petitioner was given the right to make medical decisions with the very clear exception of what petitioner is asking for the right to be able to do now, which specifically is to give the child gender-affirming care, puberty blockers, opposite sex hormones, bottom surgery, that kind of thing. So that's what's at issue here. I'm not done. That's what's at issue here, Judge.
Okay, well, hold it. So mom has sole legal custody. Are you a family law lawyer?
Yes.
Help me out. Mom has sole legal custody over everything but medical care?
Yeah, since we're the moving party, I would like to just clarify what was requested. So the parties in this matter, their marriage was annulled. The court created a parent-child parentage action. Parentage was established, and they've been disputing custody since 2016 or 17. I would have to check that date. All the prior rulings from the Texas case have been filed. We filed all the out-of-state court orders.
Got it.
In 2021, my client was granted the equivalent of sole legal and physical custody of both children, with the exception that mother cannot unilaterally consent to specific types of gender-affirming care without the father's consent or a court order. Father only has supervised visitation with the children.
You need to slow down.
Sorry. Father only has supervised visitation with the children.
Both?
Yes.
But we're not dealing with the other one.
No.
I apologize. I don't recall.
Jude.
Okay.
And mother has sole legal custody over all other issues. And there are specific orders in this case from Texas that have been found to be in the child's best interest, including a gag order, because there was a ton of national press around this case, including involvement by the Texas Attorney General and Governor. There is also restrictions as to what information father may have, including where mother and the children are living, what doctors they are seeing.
Okay, and all of those orders are in the
Home court.
RFO.
No, Your Honor, they're all in home court.
Well, but they're okay. They're all in my court file.
So in February, we filed a request for order where my client is specifically asking to modify that exception. And as stated in her RFO, she is not asking the court to determine what type of medical care the child should have. She's asking the court to determine which parent would make the best decision in the child's best interest.
So legal custody.
Correct.
Got it.
Alternatively, tie-breaking authority.
I'll tell you right now that I've been doing this a little bit of time. Tie-breaking authority is sole legal custody. So coming out of this court is either going to be sole legal custody or no change in the order, I guess.
And also alternatively tie-breaking authority to the child's treating physician.
Not good. I can't.
Okay.
I can't delegate a judicial decision to a third party.
So that was the request. We filed it in February. It was originally set for hearing in April, was continued out to May, and has now respondent is asking for this to be a long cause trial.
Okay.
It is our position that this does not need to be a long cause trial. It's already been made one. We believe they are in the wrong venue. They're trying to challenge the legality of gender affirming care. We are seeking an order as to solely the issue of sole legal custody.
Sorry, we are challenging the legality of
Gender affirming care?
Okay. So
May.
I didn't go to medical school. I'm not going to determine that gender affirming care is illegal or not illegal. The only question before me, as I understand it, I haven't read the papers, as I understand it is whether mom should be granted sole legal custody for all the remaining issues coming out of the Texas case. Is that right?
That is absolutely correct. And because the child is now actively in puberty, time has become of the essence, because mother is seeking to start the child on puberty blockers, which needs to be done within a certain time window.
Okay.
And we have concerns that this request for a long cause trial is merely a means to delay.
Your Honor, may I please respond?
Well, there's really nothing to it. Well, sure. Slow down.
Yes, sir. Absolutely. So first of all of those issues are a way to hide the main point here, and they, as I understand it, are to be put before Judge Kazan. So sorry, thank you, Judge Kazadi. I'm new to Los Angeles. So the annulment, all that's not relevant, Judge. It's kind of playing hide the ball. Again, what's at issue here is the best interest of the child. Is it in a 12-year-old boy's best interest to stop his puberty and create all of the things that go with that, like a micropenis, like brain damage, like osteoporosis? That is the issue. So what needs to happen for the trier of fact, Your Honor, is that you need to be informed to make an informed decision. And that absolutely, in this case, requires medical testimony. A 12-year-old boy's life is at risk. So we're not trying to delay. We have scheduling issues with experts. We need to do discovery. For example, Your Honor, we've served written discovery on petitioner April, and we have not received one document. Just to be very specific, as an example, Your Honor, we've asked for who the treating pediatrician is. The only document that's been provided is an exhibit to petitioner's reply declaration that purports to be a medical exam that is redacted and doesn't even have vital signs. So what is before the court in the pleadings is incompetent medical evidence, and there is no way the trier of fact can make a decision based on the evidence before the court. So at this point, it's merely a scheduling order, Judge, and we have discovery rights, and we want to employ my client wants to employ those discovery rights. We'd like to do we're going to refile the motion. The home court judge, Kazadi, actually ruled this morning that there was no exigent circumstances for an IME, which goes to the point that there really isn't any exigent circumstances. A young boy going through normal puberty.
Okay, again, I get that this is a very emotional case and all those things, but you really got to slow down.
Am I going too fast? I'm really sorry.
The court reporter is really good at what she does, but you're making her life totally miserable. And
so where should I start over?
In fairness, when you go that fast, I can't really track all you're saying very well either. Slow down. It's another hour and a half before we have to go away. An hour. Okay, so just slow down. So the question is, how long is this case going to take to try? And are you ready? And then we sort of build back from there.
Okay, so to answer those questions, we determined earlier this morning, 2 to 3 days after lots of back and forth with Judge Kaufman.
Okay.
And no, we are not ready, Your Honor, and it's mainly discovery issues. For example, I have not even seen a petitioner's witness list. There are several people, we went through it with Judge Kaufman, Judge, and there are several people, for example, Danielle Hurwitz is an LCSW who purports to have diagnosed James with gender dysphoria. I need to depose this person, see the letter, right, that purportedly does that, get the facts there so I can properly cross-examine that witness, and on and on and on. We have served written discovery. We've received non-code compliant responses. I have met and conferred briefly, cursorily, with petitioner's counsel, and she's gone until Monday, so I'm going to get her an extensive meet and confer letter. I'm hopeful that we can work it out, but otherwise a motion to compel is in the works. And Your Honor, there's allegedly a treating psychologist that we'd like to depose as well. So no, we're not ready.
Okay. So is the LCSW and the psychologist, psychiatrist, are they local here in Southern California?
Yes, Your Honor. Well, we really only need them as to authenticate documents.
Okay.
And I just like to say, this issue has been ongoing for years and years and years. In fact, the person that we have on our witness list, which has been served on counsel, was deposed by respondent already in Texas. So they have had years of doing discovery on this issue. We filed this in February. We responded code compliant with discovery. We're ready tomorrow.
Got it. So 2 to 3 days? Do you need
2 days max, I think.
Well, how? So I show on July 10, Hamilton Heinberg. Oh.
Just so you know, Your Honor, we are between the expert, Dr. Grossman, and I don't have any 2 or 3 day blocks in July, and she doesn't either.
Well, but what about July 8, 9, 11, 12?
No, we don't have those. I can give you dates if what's easier for Your Honor. So my expert is only available August 1st and 2nd. I have hearings on the 1st, so if it's only a 2 day block, that doesn't work. September, any time except the 26th or 27th is probably the earliest September.
How about August 1st and 2nd, 5th? What? Oh, okay. August 12, 13, 14, I don't know.
I have an arbitration on the 12th that week, and my expert's not available.
Every single date that has been put forward, including by Judge Kaufman, every date that has been put forward, including by Judge Kaufman, they have been unavailable. Like I've said,
Objection,
I believe this is a delay tactic.
Stop. Look, I was a civil lawyer too. One of the basic tenets that I knew in a courtroom is one person in a courtroom talks at a time. One person.
I can make any of the dates proposed.
Okay. So I'm really reluctant to go past August. I'm not going to go into September. So if we need 2 or 3 days, we'll do 1 day, 2 days, that sort of thing. So that's how we'll do this. So you tell me, how do you want to handle this? When is your expert available?
August 2nd, Your Honor, I would have to start in the afternoon.
Okay.
No, I'm sorry.
It's not going to be on the stand the entire time.
I understand that, Your Honor, but it is good cause under the Civil Code if an expert witness is not available.
Okay, August 2nd in the afternoon. Can you do him or her? I don't know why. Can you do him or her in half a day?
In terms of the order of presentation, are we going to let respondent go first, or is it petitioner will go first?
It's her burden, right? It's your RFO. It's her burden.
So she would go first. So
we can start on August 1st. We won't need your expert until maybe the August 2nd in the afternoon anyway, and we can take somebody out of order.
I'm not available on August 1st. I'm sorry, Judge. I apologize. I have other cases.
You're not available the entire week of August 5th.
No, 12th.
Oh, what about August 5th?
Let me look.
I'm just looking at the week. I know. Well, that's just a trial center conference. We got nothing the rest of that week. I'm just looking at the week of August.
That week for me, Your Honor, works.
How about your expert?
I'm sorry?
How about your expert?
No. She only has August 1st or 2nd, Your Honor. But I'm happy to start and continue in September if that pleases the court.
I'm not going to do that. What if we take your expert out on the afternoon of August 2nd, and then start on August 6th, 7, 8, 10.
I think that would work, Judge.
Perfect. So we'll set this matter. Is that okay with you to take this person out of order?
Sure.
Have you deposed this person?
No.
Do you know who it is?
Yes.
You going to plan on depose? Is it a him or her?
To her.
Are you going to plan on Dr. who?
Dr. Miriam Grossman.
Dr. Grossman. Are you going to depose Dr. Grossman?
I don't think actually it's necessary.
And what kind of doctor is Dr. Grossman?
She's an MD and a psychiatrist.
Do you have witness lists and all that stuff?
Yes, it's all filed, Your Honor.
Exhibit lists all done? I mean, yeah, exhibits exchanged and all of that?
Not exchange, but we filed a pretty extensive exhibit list, yes, Your Honor.
Got it.
Yeah, we haven't exchanged exhibits, but we have both submitted exhibit lists.
Got it. All right. So let's do this. Let's start August 1st at 1:30. And then I'm going to schedule the rest of the trial for August 6th, 7, and 8. I'm sorry, August 2nd, my mistake.
All right, just to clarify, you said August 1st, beginning at 1:30.
Lied. August
Okay.
2nd at 1:30. And then August 6th, 7, and 8. I don't think we're going to need all that time, but I want to block out all that time nevertheless. And that will be all day, every day. And then once that expert has testified, then the petitioner has the burden of proof. So we're going to take Dr. Grossman out of order. There are local rules that talk about exchange of trial briefs and documents and all that good stuff. So I just follow the local rules. How many exhibits are there going to be likely, roughly? Hundreds or a few?
I can't answer that, Your Honor. I would say 10.
Oh, so not many.
We filed, I think, several, but I just can't answer that question right now, Judge. I'm sorry.
So petitioner will have exhibit number 1 through 500. Respondent will have exhibit number 501? Yeah. 501 through. I need one hard copy of all the exhibits. Are there going to be videos?
Yes.
Videos or audios, any of that sort of stuff?
Possibly, yes.
Possibly.
Okay. So there needs to be one hard copy of all of the exhibits. That's the official exhibit. How you exchange them with each other, I don't care. If you want to do it electronically, that's fine. If you want to do it hard copy, that's fine. I need one copy. We're going to do this live. It's not going to be remote. I need one hard copy then for the witness stand, or one copy for the witness stand. If that's a computer or a pad or something, don't care. Whatever you all agree by way of how that is handled. If you have a video or an audio, each one has to be on its own thumb drive. So assume for a moment there are 10 videos. I can't have one thumb drive with 10 videos. I need 10 thumb drives. The court has not yet caught up with the 2024 technology. Not sure when it will, but we are where we are. If you have a video, you have to have some way to show it. Sometimes I can do it through this on the TV screen. Sometimes I can't. It's a moving target. Any order out of Texas I'm not disturbing in any way at this point. So if somebody said there were gag orders and all of that. If that's right, that's right. I don't know. But so those aren't, I'm not modifying or changing those in any way. I understand that on May 30th, Judge Kazadi, the minute order says, the court grants the petitioner's request to seal the case and orders that all future hearings in this case shall be heard in closed courtrooms. So, pursuant to the family code, 215 or 2 something or the 211, I don't recall, I can close the courtroom in essentially the best interest of a child. So I will happily close this courtroom for all hearings. I have no idea who's with Mr. Baker. I have no idea who's with Dr. Georgalis, I apologize. So I can't control what I can't control. So the only thing I can say is that if there are other people in the room that have nothing to do with this case, with cameras off and all of that, I can only say you can't do that. And so how all that shakes out, I don't honestly know. There's a very strong public policy for open courts in the state of California, a very strong public policy. In my humble opinion, you cannot seal a file, especially on an ex parte. I cannot modify another court's order. I'm not going to. But I have real problems with the idea that this case is, quote, sealed.
There was a stipulation made this morning between both counsel with Judge Kaufman that the case was meant to be made confidential, not sealed. So it has been deemed confidential and not sealed.
By whom?
Judge Kaufman, with an exception that any medical records of the children are to be sealed.
And that's her order.
Yes.
Your Honor, just for the court's edification, it was the home court judge that ordered it sealed, and it seemed to be like a coding error, and that was just clarified with Judge Kaufman. But the home court judge did not hold a hearing, so I actually respectfully agree with Your Honor. And my client is we don't know where we are with this, but we're considering challenging that. You can file a writ. Yeah. Or not. It's you do what you want to do. But I just want to say I agree with Your Honor based on the law. I also can't modify in any way Judge Kaufman's order. So I don't know whether you can make this case confidential or not. But that's what she did, and so I don't know.
Sure. I briefed on why this case should be confidential, and we did have a hearing on May 30 with Kazadi on it. Okay. All right. So there you go. So I am bound by other orders. So any questions or concerns or issues at this point? So just because I'm a civil litigator, Your Honor, as I understand it from Judge Kaufman, and please correct me if I'm wrong, is that any discovery motions go to home court? Correct. Okay. So just for Your Honor's knowledge, we're probably going to be bringing several of those and trying to do depositions, that kind of thing. Great. We'll see what happens. Right. There's a whole code of civil procedures. Yep. Tells you how to do all that, as you know. I love it. Yeah. I understand it. Up to Judge Kazadi, you go. Got it. By the time you come back, I will have obviously read the papers and know a whole lot more about what's going on. So maybe I'm wrong. You're not local. I am local. Oh, why did I think you were from up north? You're from up north. Got it. My mistake. And you're going to be here in person, right? Yes, Your Honor. Okay. There's hotels and airplanes. No, I got it. I just trying to figure out whether are any witnesses going to appear remotely? Our expert's planning to fly in, and my client will be in person. Got it. Is flying in, and my client will be in person. Got it. And there's no remote witnesses from your standpoint at this point? Not that I know of. They're all local. Okay. Is anyone, is there an issue about whether this child is going to testify? Neither party has made any requests as to the child testifying.
Okay. Okay. If that is a request, we need to talk about that, and then whether there would be a minors counsel that would be appointed at that point or not.
Okay.
So we need to talk about that. Unfortunately, over the past couple of months, the best minors counsels have all been appointed to the bench. So we'd have to think a little bit about what that would look like and who it would be. But there you go. All right. Notice waived on all these dates.
Yes, Your Honor.
Any other questions? Any questions at this point?
No, Your Honor.
Okay. Sure.
Confidential.
I don't know. I can't. I don't know. Right. Well, the parties should have access to the transcript.
Right. Closed session, which generally closed transcript, separate, but that's the order.
Sure. Okay. So is your understanding that this transcript can only be reviewed by the parties? Attorneys and parties?
No, well,
So can counsel give Dr. Grossman a copy of this?
Yes, that would be our request, Your Honor, to prepare.
I'm not going to rule on that. That's not before
the
me.
confidentiality rules of, I believe it's 7643.5 that have governed all parentage cases prior to January 1st, 2023, and cases involving assisted reproduction would apply here.
I'm sorry, Family Code Section what?
I believe I have to check my brief, but I think it's 7643.5.
Your Honor, this is not a parentage action.
764.35?
Hold on.
I've got .5.
Let me pull it up so I can give you the correct code.
So this code cited by petitioner's counsel would not be applicable, Your Honor, because it's not a parentage action.
We've already had a hearing on this, and respondent's counsel keeps trying to relitigate it. It was briefed and heard before Judge Kazadi.
Okay.
Your Honor, my recommendation would be to read her ruling because that's not what she ruled. The document speaks for itself, Judge.
I'm sure it does. Is there a ruling other than the minute order?
Yes, there's a FL 305 temporary emergency orders.
And just to kind of clarify, Your Honor, again, the language in Texas is different, and so petitioner's counsel capitalized on that language and made an argument that isn't applicable. This is not a parentage action. Substance over form kind of argument. The parties have never challenged parentage. Never. It's just a title thing. It's like conservatorship in California doesn't mean what it means in Texas.
Right. Well, right. Texas has a much more property sort of approach to children than California does. It's just in their language.
Yeah.
Yes, I was correct. It's section 7643. They govern the confidentiality of parentage cases filed prior to January 1st, 2023. And this case was filed prior to January 1st, 2023 in Texas, and it was initially filed as a parentage action because the party's marriage was annulled. Additionally, the rules around CRC 5.51 are applicable because the children were conceived via assisted reproduction.
I'm going to object. This has already been decided. It's irrelevant.
I agree. We had a full hearing on the issue.
So I'm not going to make any rulings. Okay.
There's nothing before Your Honor.
So you may make the appellate court busy.
Hopefully not, Judge. I'm really.
Any luck at all, right? Okay. Anything further from petitioner?
What time does It starts at 1:30, but what time does it start, your courtroom start on 6, 7, and 8?
8:30.
Thank you.
Just to clarify, since we're going out of order, I mean, I've gone out of order in many trials, but I've never gone out of order where that's the start of the trial.
The only other option is to kick it back until September.
No, I don't want to do that. I just want to know how you want us to do it. Just immediately put the expert on the stand, or do you want us to have any sort of opening statement?
So I'm assuming, but don't know, that you will file a trial brief of some sort. I read the trial brief. I'll read the underlying RFO. I'll be familiar with everything before we get started. I'm guessing, but don't know, that the expert is going to take the better part of the afternoon. And so my fear is that if we start on Friday at 1:30 and we don't finish with the expert, then the choices are either I order her back on Monday morning or I strike her testimony. So I would like to manage to get her done on that half day. So I'd rather not spend a bunch of time on opening statements and all of that. If once she's done, then you want to do an opening statement and we have time, then I'm all ears.
Your Honor, I need to throw a wrench in this whole thing. And you can get as mad at me as you want. It's my fault. But pursuant to the document, page 150, attached to petitioner's declaration, the order.
Hang on.
Okay.
So help me out.
Okay.
It's the order that was filed when?
Okay, sorry. It's Exhibit L.
Okay, what filed when?
227. I think that you guys call it an FL 300. It's PDF page 150.
Yeah.
Exhibit L.
Which is a agreed order on motion for court to surrender jurisdiction?
Correct. And if you look at the last stipulated item, my client has a right to a jury trial.
Hang on. Hold it. The last stipulated item on page...
I'm looking. It's page 2 of 5. It's number G. Findings. Finding G. 2G, page 2 of 5.
It says, respondent has requested a jury trial and paid the required fee. This court finds that respondent has a right to have the issue of conservatorship tried to a jury under Texas law. Well, a couple things. One, we're not in Texas. Texas allows for jury trials in what I'm going to call custody. California does not. And so if he wants to go back to Texas and have a jury trial under conservatorship, that would be his right. But under this, I'm not going to interpret this, that he has a right to a jury trial in California.
So
this is the very first time I'm looking at this.
Yeah, I would submit to the court for consideration, full faith and credit. And if you look at the orders, number 4, page 3 of 5, maybe Your Honor could take this under submission.
No, I know.
Okay.
Orders what? Okay.
Under the full faith and credit clause, the court, all parties and everybody else in the world agrees that all current pending actions, skip, parties further agree, and it is further order that all final orders, temporary orders, orders on discovery, shall be filed with the Superior Court and shall remain in full force and effect. And so I submit for the court's consideration that the only issue here is I could offer a stipulation that a jury trial be done under California law. And if petitioner will agree, we just have a jury trial under California law. Problem solved.
May I respond?
I take it you're not going to stipulate to a jury trial.
Absolutely not.
Right.
So Respondent's counsel is trying to relitigate things already addressed in court. We had discussed this issue with Judge Kaufman this morning.
Slow down.
I apologize. We discussed this issue with Judge Kaufman this morning, and she already denied their request for a jury trial. That's 1. 2, their order says he has a right under Texas law. I would argue that even under Texas law, which is, I have the code Texas 105.002, which is a right to a jury trial, the court explicitly says the court may not submit to the jury the question of any right or duty of a conservator, which is exactly what we're trying in this case. Third, the California Code of Civil Procedure, Section 592, does not allow for jury trials in family court.
Yeah. So let me look at this. I'm more than happy to take a look at it, but I'm going to deny your request. If you want to make a formal request, I think you need to do that and explain what conservatorship in Texas, all that kind of good stuff is. But I'm not going to rule on the fly because, again, it's not fair to the parties or, frankly, to your child. So
I appreciate that, Your Honor. Thank you.
all right, anything further from the respondent side?
No, Your Honor. Thank you very much.
Very good, thank you. Then notice is waived on the trial dates. If there's motions in limine, all that, we need to talk about when those are going to get heard. So there you go. But you can just call the court and we'll set up a conference call or something. Figure out how we're going to schedule all that.
Call Your Honor's clerk?
Yes.
Okay.
Yes. Mary is remarkably good at what she does.
Yes, she is. She got me an order I couldn't even get.
There you go. All right, thank you very much.
Thank you.
Your Honor, have a nice rest of your day.
You as well. Did you, oh. No. Oh, okay. Yeah, okay.
Mary, I'm having a hard time reading the city for Henderson, Mary Henderson, right? Oh, no, Tracy Henderson. Is it, now? Or not?